we're going to have to get a little geeky about Supreme Court procedure and what cases they decide to hear, because we have to discuss whether or not we in the Second Amendment community should be worried that the Supreme Court may never take a case involving a law banning the use and ownership of semi-automatic rifles such as AR-15s and AK-47s, because there may never be a circuit split. We have to talk about this when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate categories for the 2024 Gundies Awards out in Las Vegas. The first category is Top Male Influencer in the Second Amendment space, and the second category is Top Voice of the Second Amendment. I'm proud to be nominated and a finalist in both categories. All right, folks, so we have to talk about when the Supreme Court hears cases and whether or not the issue of whether or not we will ever have a circuit split between federal courts dealing with quote-unquote assault weapon bans, meaning bans on semi-automatic firearms, whether or not that will give rise to a situation where we in the Second Amendment community will simply never get a U.S. Supreme Court decision that says that AR-15s and AK-47s and other semi-automatic firearms, specifically semi-automatic rifles, cannot be banned under the so-called assault weapon bans that have become very popular among the Democratic Party, especially in the blue states where they control all branches of government. Now, to begin with, let's just talk briefly about why this is an issue. The U.S. Supreme Court rarely is forced legally to hear a case, which means that the United States Supreme Court gets to have the discretion, the choice of what types of cases they hear, which is why you talk about or you hear about this discussion. Will the Supreme Court grant the writ of certiorari? A couple different ways to pronounce it. I would just say grant cert. You don't need to worry about the Latin pronunciation here. Will the Supreme Court grant cert in a case? And then, if so, how will they decide it? So the first major step, and it's very difficult to get, is for the Supreme Court to actually hear a case on the merits. There are literally thousands and thousands and thousands of cases that are heard across this great country that are then in turn requested by the lawyers and the parties to be heard by the Supreme Court. And the Supreme Court today, which really I think is sort of unfortunate, is only hearing something around 60 to 70 cases a term, where the term runs from October of 2023 through June of 2024. That's the general, October to June, the general term of the Supreme Court now. So when you start a federal case, it starts in district court. The case is over. It goes up to the U.S. Court of Appeals. There are 13 different courts of appeals. And then from there, it goes, if at all, to the United States Supreme Court. Now, one of the main reasons why the U.S. Supreme Court likes to hear cases is they like to resolve what are known as circuit splits, which is sometimes called a split of authority. Now, this situation arises where among the 13 courts of appeals, there's a disagreement about how a particular law should be interpreted or how a particular ruling should come out. So, for example, let's say you have a court in the District of Columbia saying that a may issue permitting regime for under the Second Amendment is unconstitutional, which was the case in a case called Wren before Bruin was decided many years ago. And then at the same time, you have, let's say, the Second Circuit Court of Appeals out of New York reaches the exact opposite conclusion that says may issue permitting regimes for handgun carry licenses constitutional. So there again, you'd have a issue because the same Second Amendment in the same type of issue, you have different courts reaching the polar opposite answers. And where that happens, the United States Supreme Court often likes to get involved to resolve the circuit split. Now, this is really quite sort of commonsensical. I think everyone can understand that you don't have to go to a fancy law school to understand this. But here's the reason why this really matters for issues associated with quote-unquote assault weapon bans. If you just step back and think about it for a moment, what states and what parts of the country are enacting these bans on semi-automatic rifles? Well, we know those are the blue states in the terrible anti-gun jurisdictions that you can name off the top of your head. It's New York, it's New Jersey, It's Illinois. It's California. And of course, this cancer of anti-gun lobbying efforts is spreading to other blue states like Washington and Oregon and Colorado, where the Democrats managed to gain control of the governorship as well as the state house. And now you have complete control over some of these states. And when they get complete control, there's a whole list of things Democrats like to do, including infringe upon the right of the people to keep and bear arms, as I see it. So why is this matter? This geographical understanding I just described matter. Because keep in mind that federal courts, are only allowed to opine on constitutional questions that give rise or arise from an actual case or controversy. And what is a case or controversy? Under Article 3 of the U.S. Constitution, it says federal courts only have jurisdiction over cases and controversies, which means you have an actual fight over actual laws with actual people in an actual disagreement where the outcome really matters to someone's life. It's not some hypothetical advisory view or some debate on a sports talk show about who's the better team, the Patriots or the Bruins or the Texans or whatnot. It has nothing to do with that because these are actual cases. The reason why this is critically important and why I'm bringing it all together now for you to understand is this. The same terrible jurisdictions that are bad on guns because they're liberal Democrats as a general matter, the New Yorks, the New Jersey, the Californias of the world, guess what? As a general matter, the judges, the federal judges that sit in those areas of the country that are dominated by Democratic politicians are generally speaking also picked and blessed and approved of by the Democratic politicians. So it's very difficult, for example, to become a federal judge in New York State without some level of approval from, let's say, Senator Chuck Schumer or Senator Kirsten Gillibrand. Give an example, right? It's just the way the politics works. Now, as a consequence of this, when a state like New York, New Jersey, California, Illinois, when they enact these anti-gun laws, such as banning semi-automatic firearms, semi-automatic rifles, and then there's a lawsuit brought, as a general matter, not all the time, but generally speaking, at the end of the day, these Second Amendment challenges to these quote-unquote assault weapon laws are going to go in front of judges in these same blue states of New York, New Jersey, California, Illinois. And generally speaking, the federal judges there have been blessed by Democratic politicians that are generally anti-gun. And who are these anti-gun politicians going to generally approve of for the federal bench? Those are people that have the same judicial philosophy that they have. And when it comes to the Democrats, it's really very easy to pick judges because they simply don't care, as I see it, about the rule of law. They think that all that matters in these high-profile, controversial culture war cases involving abortion, gay rights, guns, the size of government, and so on, they're just putting judges on the bench to do one thing, which is to advance the progressive agenda. Because from their point of view, virtually every law professor in America, some excluded, of course, are essentially, dyed-in-the-wool liberals who are going to think that government is a power and force for good as a general matter, and that includes government courts. So the courts are really just an extension of this progressive idea that government is good. The point is that when it comes to our Second Amendment rights, these anti-gun laws get passed in blue states, then they get challenged in these blue states, in these blue state courts by these judges who have essentially been picked for the bench by blue state politicians with the outcome you can kind of expect. And the reason why this matters to the Second Amendment context, or in the Second Amendment context, is because in contrast, the sort of favorable judges that respect the Constitution and are originalists, which means they apply the Constitution and the Bill of Rights as written, as understood at the time of the founding, which is very good for the Second Amendment community because they, the founding generation really was supportive of the right to keep and bear arms and understood it as the most fundamental of all the rights. So it's very good to have an originalist look at this case because they're going to respect the Constitution, the Supreme Court, and they're going to not try to engage in living constitutionalism and make stuff up because they think it's good public policy. So here's the problem. The red states, where these red state judges are presiding, are also the same states that will never enact gun control laws to speak of. They're not going to ban AR-15s in Texas. They're not going to ban AR-15s in Florida. They're not going to ban, semi-automatic firearms in these red states. And as a consequence, red state judges or those that are originalists in those states are never going to have an opportunity to opine on those gun control laws, because those actual laws will never be challenged in an actual case or controversy and come before those judges. Which means at the end of the day, if you look across the country, all the anti-gun semi-automatic firearms, i.e. semi-automatic rifle bans, are taking place in blue states with blue state judges who are ultimately going to approve those laws as being consistent with and okay under the Constitution, specifically under the Second Amendment. And there will never be another side in the Court of Appeals to give rise to a circuit split, which is what the Supreme Court usually likes to see before they grant cert. So you're going to have a situation here where every Court of Appeals that sits on the question of whether or not an AR-15 ban or an AK-47 ban or a semi-automatic rifle ban is constitutional is going to say, of course it's constitutional under the Second Amendment, and there will be no other side to that in the Courts of Appeals, not because that all the judges agree with what these anti-gun judges are saying. It's because there will never be an opportunity for the red state judges to weigh in on the question, because there will never be an actual law enacted in those parts of the country that can give rise to a Second Amendment challenge to them, which of course is great at the end of the day, except when it comes potentially to whether or not the Supreme Court will decide to hear a case involving whether or not banning AR-15s in a particular state is constitutional under the Second Amendment, because there won't be a circuit split. So that is the problem that many people have flagged on X and in other social media accounts and have asked me about. So I want to bring what I consider to be pretty good news, though. I think there are many reasons why we think that at some point in time, when the right time arises and there's a final judgment in a case that says that AR-15s can be banned under the Second Amendment, why that can give rise to a Supreme Court case on final judgment. Because if you look at the Supreme Court over the last several years, including in Second Amendment cases, there are many instances where the Supreme Court will hear a case even where there is no circuit split. In the Second Amendment context, let's just start there, and then we'll move on to some other examples from this term alone, or the last couple terms. The United States Supreme Court heard in 2010 the Otis McDonald versus Chicago case. That involved whether or not the Second Amendment should be incorporated through the 14th Amendment and applied to the states, because it was a fundamental constitutional right that was appropriate under the standard of review for what's known as substantive due process. I won't bore you with it right now. But the bottom line is that question was not that the Supreme Court decided that, again, the Second Amendment did apply through the 14th Amendment to the states and localities, and the states and localities were bound by the Second Amendment. That McDonald case came to the Supreme Court and was decided by the Supreme Court in 2010, and there was no circuit split. There was no other side. The city of Chicago, or I should say the Seventh Circuit Court of Appeals, ruled in that case. It went to the U.S. Supreme Court, and the Supreme Court ruled in the Second Amendment's favor. No circuit split, so that's good news. Then you look at the 2016 decision in Caetano versus Massachusetts, which of course held that the Supreme Court of Massachusetts had essentially violated the Second Amendment in a sense by signing off on a Massachusetts law that had given rise to an absolute ban of stun guns, because the Massachusetts law banned all stun guns in the state, and Ms. Caetano was convicted of possessing a stun gun that she wasn't allowed to have because it was banned. The Supreme Court in Caetano reversed and remanded that decision back to the Massachusetts state court system. And again, there was no circuit split over stun guns. There was no circuit split. Nevertheless, the Supreme Court heard the Caetano case and decided it. So in two Second Amendment cases, they heard it because it was important as a matter of precedential value and national interest, both the McDonald and Caetano case, and again, no circuit split. So the fact that there is no circuit split in and of itself is not a reason for us in the Second Amendment community to be concerned, although a circuit split is certainly helpful to get the Supreme Court to grant certiorari, or certiorari, I leave it up to you as to how you pronounce that, to grant cert. And just to give you further hope that I think that even though The problem of no circuit split is a possible issue. There's certainly in the last term or the last few years several instances where this Supreme Court, as currently constituted, is very interested in hearing major cases, even if there's no circuit split. Right here, right now, in this term alone, you have, for example, the FDA versus Alliance versus Hippocratic Medicine case. That involves whether or not the FDA violated sort of procedural rules under various Administrative Procedure Act and under federal law when they approved the so-called abortion drug, the mifepristone drug, which is the abortion pill, abortion drug, what do you want to call it, and whether or not that can be prescribed with or without a doctor, whether over the counter or not. Those kinds of administrative issues involving the FDA. No circuit split there, and yet the Supreme Court is going to hear that case of FDA versus Alliance versus Hippocratic Medicine this term. They're also going to hear another case where there's no circuit split this term. That's the Fisher versus United States case. This is one of the special counsel Jack Smith cases where he, as you know, is essentially, Jack Smith, the special prosecutor and President Trump, as well as the Merrick Garland Department of Justice, are trying to throw the book at every single January 6th person, protester, whatever you want to call those people on January 6th, and trying to turn a lot of these misdemeanor cases into felony cases using a federal statute that arose from financial scandals such as this Enron scandal for destroying documents and tampering with witnesses. And they're trying to argue, at least this is what Jack Smith is arguing against President Trump and what prosecutors are arguing against the January 6th protesters. That law applies to them because they interfered with actions of Congress. Set aside, what happens with all the protesters that were angry and tried to delay the Brett Kavanaugh confirmation, but let's not get into that right now. The point is that the Fisher versus United States case is another situation where there is no circuit split. Yet the Supreme Court is going to hear that case despite no circuit split in terms of how they interpret a particular criminal statute this term. And then, of course, there was last term the Joe Biden versus Nebraska case, which was a challenge, again, no circuit split, as to whether or not the student loan program that Joe Biden just waved a magic wand and tried to forgive $400 billion in student loan debt without going to Congress just by reinterpreting certain regulations. And the Supreme Court in Biden versus Nebraska said, no, go, you can't do that. Again, that was another major case that was decided without a circuit split. So again, a lot of examples here where the Supreme Court will take cases where there's no circuit split. And just one other example, you may recall during the Trump administration, the Trump versus Hawaii case out of the Ninth Circuit Court of Appeals in 2018. And this, of course, dealt with whether or not the president had the authority to implement additional vetting of immigrants or people coming to the country in various ways, and whether or not he could bar entry from certain countries that he viewed to be given rise to terrorism and so on, all without going to Congress. And the Supreme Court, of course, ultimately ruled in favor of President Trump after a long series of battles out in the Ninth Circuit in Hawaii. So anyway, again, the bottom line is, yes, it's a potential problem that there's never going to be a circuit split as I see it involving AR-15 and AK-47 bans, because at the end of the day, in these courts that are going to be hearing these cases, the 4th Circuit out of Maryland and Virginia, the 7th Circuit out of Illinois, the 9th Circuit out of California, the 2nd Circuit out of New York, these are generally, again, blue state courts and blue state places which are going to deal with these blue state anti-gun laws and gun ban cases, and you're never going to see a contradictory viewpoint in any of, let's say, the Southeast Conference states in the southeastern part of the United States, because you're never going to get a law to challenge, because you're never going to ban AR-15s, which, of course, is ultimately the right answer. We shouldn't have these bans. We shouldn't have to spend money on these court cases, but that's not the world we now currently live in. So anyway, the fact that there's no circuit split involving AR-15 bans and so on, I think that ultimately the Supreme Court will at some point hear one of these cases because it's of national importance and also of presidential value. But again, only time will tell, and we'll see when these cases will ultimately get to the Supreme Court. It's very difficult to know right now as to which case will be the next man up for the AR-15 and AK-47 ban cases. So anyway, there you have it. Hope you learned something today. Hope it wasn't too geeky. Again, feel free to subscribe. Make sure you haven't been unsubscribed. Follow me on X at 4Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.